Where's the link to the camera? I'm not finding it.
So you may see the logo icon of camera and mic on the top of the toolbar.
Yeah, am I visible now? Okay.
Yep.
Yeah.
Now you are visible, sir. Please set your camera. Please set your camera.
Yeah. I think I should take it down.
Now fine, sir.
It's fine, I think, huh?
Now it's fine. Yes.
Yeah.
Okay.
Okay.
So,
Hello,
sir,
friends.
shall we start?
Yeah, you can start.
Okay. Guys, please maintain the silence, right? So we have today Dr. Mohit Mahajan, right? Mohit Mahajan has been at the cutting edge of confluence between science and law for the last 20 years. A registered patent agent since the year 2000, is among the pioneers in India who practically harness the synergy between the professionals streams of engineering and law. Worked at as consultant with the Council of Scientific and Industrial Research, that is CSIR, GOI, Government of India, New Delhi. Earlier worked with FITT of IIT Delhi as their principal consultant. Technology transfer and IPR for 15 years. He has been a personal witness, assessor, and evaluator of more than 900 inventions, of which more than 300 are filed as Indian and foreign patents applications. In addition, has negotiated and effected more than 30 technology development and transfer agreements. He is a trained mediator and arbitrator in the area of intellectual property rights, technology licensing, business incubation, and industry academia partnership, and has guided numerous researchers and scholars in this area. Hello. He is currently the CEO of Center for New Product Development, Trade and Transfer. Right? So, Mr. Mahajan, please, you can continue. The students are here.
Yeah. So, hello, students. Nice to be here amongst people. I'm the CEO of Center for New Product Development, Trade and Transfer, as Mr. Saket Kumar has just introduced. Thanks for this wonderful introduction. This organization, Center for New Product Development, Trade and Transfer, is a NGO. It's a science and technology NGO, or let me call it a technology promotion NGO, the primary purpose of which is to bridge the gap between industry and academia. And the philosophy of this Center for New Product Development is to use the IPR system, the intellectual property management system, to bring out technological innovations from universities to help develop new products for the industry. Now, students, we know that IPR in universities has been there for quite some time now, for more than 20 years. Universities around the country have been producing good numbers of patents, trademarks, copyrights. However, the intellectual property from universities is still not rated very highly, very respectfully, because the conversion from intellectual property to product development is very, very low, dismally low. For the fact, in fact, that Patent Office of India has a category. Whenever there's an invention, whenever there's a patent, they call it whether it's an academic patent, and they see it in a, they accord a less strict criteria of evaluation to an academic patent as compared to a patent emanating from the industry. That's not something that that should give you a lot of good feeling that wow, your patents will be considered leniently, and there is a better chance of having them granted easily. Rather, it's a sign that for all your effort that will go into making a innovation for getting a patent in India, the respect, the credibility that it will carry is considered less, will be rated less than an patent emanating from the industry. So this organization, the Center for New Product Development, has taken upon itself this mandate of enriching not only the number of patents coming from universities, but to improve their quality so that the conversion ratio of patents from universities into products, tangible products, increases dramatically. Friends, am I audible clearly?
Yes, sir, you are audible.
Yeah, thank you. So, see, we are an organization with all our people. We are a 15-member organization. All of us have worked in the R&D departments of India's premier most labs, IITs, Council of Scientific and Industrial Research Laboratories, ICMR laboratories, DRDO laboratories. We are all from government R&D labs. So we carry the true legacy of India's R&D system, if I may be allowed to say so, because we, having worked with these organizations for such a long time, we know what actually works in India and how to make a small or say a little innovation convert into a tangible product, what is actually required and what we need to facilitate in order to do that. So I will start this discussion, on this very auspicious day of World IPR Day. First of all, have my heartiest congratulations to this fraternity, the IPR fraternity, and all those students who want to learn, who are still new entrants to this fraternity of intellectual property rights. This is the day that has been marked by WIPO, World Intellectual Property Organization, to mark the intellectual property system that is prevalent around the globe. Now, why do we, to start this discussion, I may ask this question, why it is important for students, I'm given to understand most of you are first or second year students, why it is important for you to learn about IPR? How does IPR crosses roads with your careers? What is there in this IPR regime that you must know at this stage? And even this is, in fact, this is the right stage, if not late. You now even IPR, elementary education on IPR has been introduced at school levels also. But having learning it at the first year level is an absolutely appropriate time to do so. So why you should be learning IPR, why you should know what an IPR system is and how you can benefit from it. Now, many of you, after completing your course, would not be tending to go for employment. Many of you would want to start a career as an entrepreneur, or starting. Maybe many of you, your parents have businesses running on their own, so they may not have to have a startup company. Instead, they may follow into the shoes of their family business. But those of you who have, who decide to take this entrepreneurial journey on their own and start their own business organization, start their own companies, this paradigm of IPR is of utmost importance. That is of far more importance, particularly to those people who are going to have their own startup companies, who are going to have their own businesses. But my question, the centrality of my discussion remains on why this IPR is important for technologists and entrepreneurs at this early stage of their career. So let me take you put this question right back, say on ourselves, myself only. See, when we ask this question, why you should have a patent or say a copyright in your name at an early stage in your career, so the very conventional answer, a traditional answer that you get is that see, it helps boost your CV. Some would say that um, tomorrow if you have a startup, it will help the valuation of the startup. Somebody would say that it you know tomorrow if you have to sell your startup, of course this is linked to valuation only. It is easier to get funding from venture capitalist companies if you have a good number of patents in your name or in the name of your startup. So these are traditional answers. These are conventional, ready to offer answers to anybody that why you should be sitting on a corpus of a few patents, uh, any university student. And this is not just true of India. Around the globe, say technical university students, many of them have one or two patents, and unless if you don't have, or rather I would say if you have, it gives a big boost to your career right in the beginning. But let me give you an unconventional answer, an answer which is not very much in vogue, which is um, um, which is to say that, which is not to say that these traditional answers, these conventional answers are not up to the mark. These are not wrong, but to see them in the right perspective, I would want to say that valuation of a company or inviting investment for a company would come even 3 to 4 years after you have started your company, your startup company. You are currently not at that stage. You are 2 or 3 stages behind that. You are yet to form your company, or even you are even yet to form your business idea. You are at a much prior stage. So incentivizing you or motivating you with a reasoning that you should have a patent because so that tomorrow your company will have a higher valuation, or tomorrow you will be able to attract good investment from the funding community is not, in my view, it's not going to incentivize you, it's not going to motivate you to have um, to start working on an R&D project that will lead to a patent or a copyright. There, a different answer is warranted for you people who are yet to form their business ideas, who are yet to form their startup ideas. A different reasoning ought to be given. So my reasoning is what my discussion today is all about. So before before getting you or delving into the um, this IPR scheme, let me ask you, what is the difference? Just, please attend to this question. What is the difference between a startup and a business, any business? Why do we use this word startup for a innovative business? I hope, I wish we had a two-way communication, but since it's only one way, I will have to answer my own question. Um, see, innovation is not just the preserve of startups, and the startup or entrepreneurial community is not uh, resting only with the IPR is not resting only with startup companies. IPR has always been there. Innovation has always been there in the industry. So that kind of innovation is referred to as corporate innovation. In fact, if I may be allowed to say, your neighborhood around your houses, the grocery store where you go every day, the shopkeepers in your neighborhood, they are most of them are business people. These are all shops. They are running some kind of a business. We don't refer to them as startups. Why? And let me tell you, it takes all that difficulty which it takes for a startup. To these people also, when they start their own business, it is not easy. So they are also business people, but they are not referred to as startups. These people, your neighborhood businesses, they are not resting on any kind of IPR. However, nevertheless, they are businesses. So now compare this to corporate innovation. Let me give you some examples of corporate innovation. You must have heard of, there are a number of case studies. There are some very popular case studies like the 3M case, or the Sony Walkman case, where if you have gone through this literature, where big innovations, big inventions have happened in the corporate world. These were also not startups. Sony was not a startup when it brought up Walkman, or Minnesota Mines is a company which brought something as simple as these flags that you put on paper, because they developed an adhesive which turned out to be a bad adhesive, which was not a good adhesive. So they said that, what do we do now? We have invested so much in this adhesive, and it has turned out to be a poor quality adhesive. So somebody found a way, a product where we need a poor quality adhesive. These flags we stick on paper, and it is easy to remove them without flicking out the paper itself. So they made a product which became so popular and so good selling product, even compared to the main products of the company. So these and many other examples of corporate innovation are there. They also have patents on these, but still these are not called startups. So centering my discussion on why startups need IPR more than anybody else, more than corporate innovators, more than business, your neighborhood businesses, your grocery store and all, for the simple reason that the definition of startup means an organization, a business which is based on an idea which can be scaled up very rapidly. In fact, the venture capital community says that if an organization is not sitting on an idea which has a 10x scale up capability. 10x means if a normal business can scale at the rate, can scale at X rate, then a startup should be able to scale up their business at a rate of 10x. So the VC community says that if your business cannot scale up at 10x rate, it's not a startup. It's a normal business. You're just like any other, business, and while you should be given the facilities that government and the investment community gives to startups, why you should be given that? So the question is, what kind of business can grow up at a 10x rate in order to qualify as a startup? The answer is only a business that is sitting on a very, very bright idea. Unless you have a very unique, scalable, and workable idea, first of all, it will not qualify as a startup idea. And if it does, then the first and foremost responsibility or onus on the owner of that business or owner of that startup will be how to protect that idea. Because based on that idea, you are soliciting investment from the investment community, facilities from the government. Government extends this under the Startup India scheme. You can register your startup and avail a lot of facilities. So you should qualify as a startup only if you are sitting on a multi-million-dollar idea, and your idea should not be copyable by just anybody. So the first and foremost onus which remains on the shoulders of a startup CEO is to protect his IP. So I hope I am clear when I differentiate between startups and corporate innovation, and even between corporate innovation and the businesses that we see around us all the time, family businesses, all kinds of businesses. No, none of these qualify as startups. But the definition of a startup is a business, a new business venture, which is sitting on a 10x scalable idea. And the first and foremost responsibility is to protect that idea. And the scheme of protecting the idea legally is called the intellectual property rights regime. It is the intellectual property right regime of a country which enables you to protect your idea before you start developing it further. So, see, just having an idea, developing an idea, and enforcing an idea in the marketplace is a very, very long journey. Even the smallest or the simplest of product ideas, which these days fall in the category of softwares, which are considered to have a very short shelf life. Even to develop a software program, to test it, to put it on a system, and then launch it in a market, um, is normally it takes about 3 to 4 years, sometimes even 7 years. If we move to the other category of inventions like biotechnology, chemicals, life sciences, pharmaceuticals, the shelf life of an invention is as long as about 20 years, 10 to 20 years, because the development time that it takes to test a pharmaceutical molecule or a biotechnology process is very, very long. So, patent, although the patent system is best suited for these kinds of inventions, biotechnology, pharmaceuticals, the patent system is now being changed and modified constantly by the government so that even small time innovations, ideas like design ideas, like um, know-how based ideas should also be able one should also be able to protect those under patents. And now the Indian Patent Act has considerable flexibility that you can protect almost any kind of idea. And I will expand on these the nature of these ideas in my subsequent discussion. Please note down all any question that you have. I will give sufficient time to you to ask your questions. So, moving on to the intellectual property regime, what should be the nature of the um, uh, the product or process that you want to protect under a patent or a copyright trademark? What kind of you know what kind of product or process it should be, and what protection it intellectual property system will allow it if you go for this protection. So I want to, in order to make you understand this, I want to give you an analogy. Um, and the analogy is very apt for students at this stage. Uh, when I think my photo has gone from the camera. Um, anyway, so this intellectual property system for startups and particularly for students who are yet to make a startup, leave a business, a startup idea, what should be the nature of that idea? Is there a disconnection? Am I audible?
Yes, sir, you are audible, sir. Sir, are you there, sir? Am I audible to you, sir? Sir, am I audible?
Yeah, now it's on.
Now, am I audible?
Yeah, so I'm turning off the phone
Yeah.
and I've connected back. Thank you.
You can turn on your camera and you can start.
Yeah, just a second. I'll do that. Yeah.
Yeah, you are visible, sir.
Yes, yes. Something to that. Yes. So I was discussing about what should be the nature of the innovation that is worthy of intellectual property protection. So in order to make this easy for you to understand, let me compare this with a business plan. See, the first and foremost thing that any student of your age who is yet to conceive a business idea is a business plan. Now, where does intellectual property fit into your business plan? So when we think about business plan, we think in terms of the marketing plan, the HR plan, the operations plan, that what product you will develop, um, how you will market it to a particular your target customer. Where does IPR fit into it? After all, we are discussing startups, and you are a prospective CEO of a startup. You are at a stage when you are developing a business plan, and you are being incentivized to make your business plan IPR based. It's a very logical question that will come to you, that why IPR based?
Sir, your mic is not working, I think. You're not audible.
Am I not audible now? Hello? Just a second. Am I audible now? Can you hear me? Friends, can you hear me now? Yeah. Am I audible now?
Am I audible?
Hello, friends. Am I audible? Can you hear me? Um, Mr. Saket, what we can do about it? Seems like my mic is not connected. Am I audible?
Yes, sir. Yes, sir. Now you are audible.
Okay, so seems like now if everything is on, then let's go on. So please join back. Sorry for this interruption.
Yes,
I
sir.
think
Yes.
the wire of my mic is a little loose. Or
You may
that,
continue, sir.
yeah, I don't know what's wrong. Now it has suddenly started to work well. So please try to focus back on the topic. It's going to get better as we move on. So the question that I was discussing was that as a first year student, you are yet to conceive your startup venture. That means you are yet to develop your business plan. And that means if you are yet to develop your business plan, what should be that important component of your business plan which will incentivize you to uh, adhere to the intellectual property regime? Why you would think that your product or process should in any way have an intellectual property protection? So, in order to understand the importance of this, please understand that the product or the process. Now, all businesses are not necessarily product based or even process based. There are a number of businesses. In fact, in India, most of the businesses are service based. Now, when you will grow up, you will know that a service based business is nothing but a process based business. Now, see, this is a more of a technical definition that you will learn in management school if you go there. But at this stage, it should be easier for you to understand that any product-based plan would have a tangible product outcome or a process outcome, and the process outcome includes even a service outcome. So, to give you an example, that suppose you are giving a software service, then the various steps by which you will give this service to your customer become the steps of a process. So every service can be defined in terms of a steps of a process. Whereas every product, a tangible product, can be defined in terms of its constituent particles or constituents, ingredients. Intellectual property usually protects these constituents of a tangible product or the steps of a process. That's all. So all kinds of businesses, all kinds of business plans, their product or processes can be protected in the form of either the constituents of those products will be protected under IPR, or the steps of the process will be protected under IPR. So virtually all kinds of business components, business product components can be protected under IPR. Now, this is a very broad definition of IPR that I have given you, but it's very important for you to believe in this definition, because if you'll go to a patent lawyer, he will say, no, this is something that you can't protect, this is something you can't protect, so you have no way of protecting it. You have to develop this protection mentality. This is also called, in the business world, we call it defensibility. That once you identify that you have a 10x scalable idea, then your mind should be looking for ways to protect it, ways to defend it. So that once you start developing that idea, you will invest so much, you will seek funding from sources. Later, you should not find that your idea has been copied by someone. And you should not even be limited by the limitations of the Indian intellectual property system. See, every country has its own intellectual property system. Some countries have a little narrow system, conservative system, whereas other countries have very broad intellectual property systems like US, Japan. So if you have developed an idea which is a tangible product-based idea, and tomorrow you are told that no, Indian patent law doesn't protect it, or Indian copyright law doesn't protect it, you have to find ways to protect it before you start investing and further developing it. That only means that if needed be, you may have to protect that idea in another country where it's possible to protect it. And this also means that if it is not protectable under patent law, you have to find alternate ways of protection. So I still give an analogy, and this analogy is with respect to something all of you might be knowing. um, the technology of stem cells. Most of you must be knowing what stem cells are. Stem cells are those cells which modern doctors can retrieve from the umbilical cord that connects a mother to a newborn baby. When an infant is born, there is an umbilical cord between the mother and the child. Now, when this umbilical cord is broken, the cells of that umbilical cord, in fact, these are called umbilical stem cells. There are stem cells that can be obtained from other sources from human body also. Um, However, these are umbilical stem cells are believed to be the best kind of stem cells. Why? What is that unique property of stem cells for which these are being preserved by various people, particularly people who have some kind of a disability or some problem, and they don't want that their children should tomorrow develop that disability? Then one way, I'm not saying that's a foolproof way, um, because stem cells has a unique property that those cells can be converted into any part of your body. Suppose an adult whose stem cells have been preserved when he was an infant, his liver is damaged, those cells can be converted into a liver cell. If his eye is developed, these cells can be converted into an eye. If his leg is completely broken, these cells can be converted into a leg. Intellectual property components are like these stem cells. In fact, they should be like these stem cells. Most lawyers, most intellectual property attorneys do not identify this quality of a intellectual property component. That if that particular aspect of your idea, which enables you to convert that idea into a new functionality, any kind of functionality that your final product needs, if it cannot lend this feature to your patent, then this patent is not worth the paper it is written on. Please understand that a patent, your intellectual property component must essentially have this stem cell property, that you should be able to give this any application that you want in your resulting product, in the product that you will eventually launch in the market. Are you with me? Are you uh, what I'm talking? Is it making sense to you? See, this is, of course, the discussion of this level is not going to be very basic. You will have to involve your head into it. So, a patent or a copyright, or for that matter, any kind of intellectual property, unless it has this property of a stem cell, which enables you to give it a future functionality, which you have not even fully developed at the time of uh, at the time of
Am I audible?
Yeah, I think I'm back there. Yeah, I'm back there. Yeah, yeah. Okay. Yeah. So am I audible?
Yes, sir, you are audible.
Yeah, yeah. So this is also a sword on my head that I have to be parallelly careful about, that I don't start, you know, the mic goes off. So please get back into the discussion. So what I hope I made it abundantly clear that this is an essential property of any intellectual property. Now, we as an organization, Center for New Product Development, has developed a toolkit for identifying that property of your product, that property of your idea. Just what I just mentioned, the stem cell-like property of your idea, which we will be able to protect in one or another form of IPR, whether as a patent or a trademark or a copyright or a geographical indication or a trade secret or even in the form of a contract. These are different forms of IPR, and these are not limited to these. There are even more. There are farmers' rights, there are semiconductor integrated circuit rights, there are at least 8 different forms of IPR that you can protect in India. The formula that we have developed at the Center for New Product Development for converting any idea into a protectable form of idea, we call it links to core competence. The word is capital links, LINKS. That you can note down. That is the crux of my discussion today. LINKS of your core competence. See, you will, when you will start a business plan, you will develop a business plan, this will naturally be based on your core competence. You're not going to develop a business plan on somebody else's core competence. So, and if you do that, that is a sure shot formula for meeting a failure. The, any business plan should be based on your core competence that you can do best. And this is also the formula for developing that stem cell like intellectual property. That if you can protect that core competence of yours, then the only job is that is left is to develop that core competence in your business plan, in your business idea. So this formula, which I call links to core competence, has 5 alphabets. L stands for location. I stands for inheritance. N stands for networking. K stands for know-how. And S stands for strategy. So I repeat, L stands for location, I for inheritance, N for networking, K for know-how, and S for strategy. We have found a way that any kind of core competence can be linked to one of these 5 alphabets, one of these 5 categories. And there is at least one or more ways of protecting this core competence in one or more kinds of intellectual property. So let me now take different examples of business plans, business ideas, and of course you can link it with the kind of business ideas you have in your mind, and identify what kind of IPR will be applicable on those. Number one, location. So you are starting a business, you have no special expertise except that your house or your place of business is located at such a place which fetches a lot of customers, or which is a very prime place in the locality or at a business center, or some other property of the location. And you would agree that in India, this is a very important plus point on which many businesses are built. Now, how do you protect the location advantage of your business? Now, see, as such, location advantage is the most difficult to protect, although there is one form of intellectual property which is remotely, but it is linked to protecting location. That is called the geographical indication of marks. There's an act for that. Although that is linked to um, products emanating from a particular community or a particular geography in the country, and then you can protect it under this act if it happens so, like for instance, the Kolhapuri chappal, the Banarsi sari, and there are 2,700 different geographical indications that are already registered in India. Why I'm giving you this example of geographical indication, it's very unlikely that you are going to develop a product which falls into the geographical um, um, the which falls into the geographical hotspot of your area. Suppose you happen to be in Kolhapur. Suppose you dwell from Kolhapur, and you get into the business of building Kolhapuri chappal. Then you have an option to develop to get intellectual property for Kolhapuri chappal. There are, as I said, there are 2,700 different kinds of geographical indications that you have, and there are even more. I'll move on to the other ones, and we can come back to the previous ones so that you don't lose interest as I'm seeing it happening. Inheritance. Now, what is about your inheritance that you can protect? The link seems to have gone. Hello, I'm audible. Hello, am I audible? I believe I'm still audible. Mr. Saket, I'm audible.
Yes, yes, sir, you are audible.
Right. Okay. The students, I can't see the students. That's why I got a little worried. So the second aspect is inheritance. Now, many businesses around the country, in India in particular, are family-based businesses. But that's not what I'm referring when I say inheritance. It doesn't mean that. Anything that you have inherited while you were growing up, a particular skill, a particular craft, a particular, community skill on which you want to develop your business idea, on which you want to develop your startup idea, can be protected. Now, the best way of protecting inherited things is through trademarks. If you already have some goodwill attached to that inheritance, the best way to do so is by the way of under the Trademark Act. Moving on, number 3 is network. There are a number of people who do not have a core competence as such, but they have they know the art of dealing with people. They have networks, they have friends with the help of which they can form a mastermind group and use the collective strength of that mastermind group to develop a business idea, to develop a startup idea. So how you can protect that networking? Is there a way to protect the networking? Yes. These days, the method by which you can protect your networking is called platform effects. That is also emerging as a form of intellectual property. There's no legal act to protect that, but a very effective method that world over that has become, in fact, the leading way of capitalizing on your networks, on your business networks, is by developing platforms. So this is a form of business defensibility that you must consider it as an alternate way of protecting your startup idea. The next thing is know-how. This is, in fact, the only thing that can be most widely protected under a legal IPR regime, like patents, like copyrights, like semiconductor integrated circuits. And therefore, it has become um, uh, most popular. Most of the economic activity moves around this know-how. And if you have a patent or a copyright which is valuable, then there are very good chances of converting it into a business idea. I will only say there's a good chance, but to produce a credible, market acceptable, know-how based intellectual property product is a very, very difficult business proposition. The last but not the least is S. What S stands for? It stands for strategy. How you can protect your business strategy. The most common IPR tool for doing that is trade secrets. We do not have a Trade Secret Act in India, but that doesn't stop Indian businessmen from protecting their business strategies. This is done under the contract law. What kind of relationships or business offerings you give to your customers under the contracts that you sign with them is a form of intellectual property. You cannot undermine or underestimate the importance of the strategy that you employ while you sign a contract with a potential customer, because that is where you mold your offering, that what services you are offering or what product you are offering, what sales channels you will be employing, what sales market you will be capturing. All that is covered under a contract, and contract is a legal instrument as much as a patent or a trademark. So world over, contracts have been identified as a form of intellectual property, and that's how we formulate this acronym of links: location, inheritance, know-how, networking, know-how, and strategy. All these are ways of capturing and protecting your core competence in one or another form of intellectual property. Now, if you want, Mr. Saket, please tell me, should I elaborate further or should I open the floor for questions if they have? I can do either way, because I don't know what strength of students are finding it interesting.
Okay. Hello. Am I audible, sir?
Yeah, you're audible.
Yeah. So I think they have no any question right now.
Okay, so
they are new actually in the they are first year students.
Yeah,
so if they will ask anything, then I will float the question to you.
Yeah, so let me build a little on how we do this, how we capture this links.
Sure, sir. You may continue, sir.
Yeah. So at our Center for New Product Development has developed this unique way of, first of all, identifying that hidden potential, this latent idea that you are sitting on, that even you may not have talked to yourself, or that you may not have felt confident enough to think that this idea is good enough, or this strength of yours, whether it is a location strength, whether it is an inherited strength, whether it is a strength of your core friend group, what I call the mastermind group, networking group, whether this unique know-how that you think you have, and or whether a unique business strategy that you have, we have developed a mechanism to, first of all, identify this, particularly in universities. And we have already demonstrated it at 3 different universities in a big way and met with exceptional success. And the most important case was IIT Delhi. And the name of this program is Patent Co-Creation Clinic. We conduct a clinic, just like you go to an OPD of a hospital and meet a physician. So we have developed a mechanism whereby we come to a university and our consultants come to a university and sit there for an entire day and invite all students, anybody who has any kind of idea, and not that idea need not necessarily be a know-how based idea. As I said, an idea which is based on any of these LINKS. You can come and discuss with us under a confidentiality agreement. This confidentiality agreement will sign with the university. And we identify that idea and precisely put our finger on whether it is possible to convert it into a protectable intellectual property right, whether we can protect this idea in some or the other form of IPR. This is just the first step under the patent co-creation clinic. See, now I'm discussing the most important part of my discussion. What happens in universities and what we have found is in our experience with universities is students come across with a half-cooked idea. Most of the times, their ideas are not fully developed, and they have a tendency to give up on developing their ideas. Let me say that this is the biggest problem with Indian technical universities. World over, researchers are not given this option. Once their the student council groups of this big universities, Texas and MITs, why they are big universities, why they produce thousands of IPRs? Because first their students are made conscious and responsible enough to identify their
Sir, am I audible?
I'm doing that. Yeah, I'm back again. Okay. Yeah. Can you hear me, students?
Yes, now you are audible, sir.
Yeah. So I'm almost at the concluding part of my discussion. So what I was saying is the difference between Indian universities and these very famous universities of the West, Stanford and MITs, is that firstly, they encourage and allow their students to identify the even the smallest and the silliest of the ideas. And the students also have to, feel responsible that this idea is worth protecting. This idea is worth something that they can develop a business plan upon, or this is an idea that they can further on which they can have investment and develop this idea. Whether it's and as I said, these could be any kinds of ideas, not necessarily a know-how or a technical idea only. And then it is the system's responsibility to find a way of protecting that time. So that is the role that we at Center for New Product Development has taken upon ourselves to find a way to protect by one or the other form of intellectual property any of the ideas that you have. So for this, we conduct a patent co-creation clinic at the universities, and our consultants will hold a one-to-one interview with you. Even they will go to your labs if it's a technical idea. and get you to demonstrate your uh, work in front of them, and then suggest a plan to you. However, if we find that your idea is still half cooked, or there is a major lacuna in your idea, we have a plan for that. Since we, all of us, come from major R&D centers of the country, major R&D labs of the country, we have our connections in various government departments. If the university allows us, we will take your idea to one of our government lab groups and ask a scientist to sit with you. Say a scientist from say DRDO or from CSIR or from IIT Delhi to sit with you and first of all understand your problem and then suggest a solution to it. That whatever is the half-cooked nature of your idea, that for some reason it is not possible to file an IPR patent on that, we will fill that lacuna. We will overcome that impediment and make it, bring it in a form that you will be able to file a patent on that. And that's not just the, at the end of the story. We are not doing it only to file a patent on it. You will be able to take a real call on converting it into a tangible product for the market. So it's a long drawn process. First of all, you have to have the confidence to bring that idea to the knowledge of the university. Secondly, our consultants should be able to identify whether this idea is ready to convert, first of all, to protect it, and secondly, to convert it into a tangible product. If it is neither ready for protection nor for conversion into a tangible product, we identify a core group in that area from various labs that, government lab networks that we have, and help you convert that idea into a protectable form, for converting into a tangible intellectual property. And then that core group only helps you to convert that idea into a tangible product. So this is all what we do under the patent co-creation clinic. This is one of our flagship products, which is most famous in universities. We have done it innumerable times with huge success at 3 universities. I will only name the government university. There are 2 private universities in your vicinity only, in Noida, Faridabad region, where we have done it successfully. And we would take this opportunity to go to your ask your university to try this out. Let me conclude this discussion with 2 other products that we have, which is called the Product Promotion Highway. Product Promotion Highway is a program which enables you to market your product. It's a marketing program. It has got nothing to do with intellectual property. It is a way by which your developed product can be marketed for ready absorption by the industry. And there is yet another product, what we call the Customer Experience Training Program. When you are developing a product, you have to know what the experience of a target customer will be for this product. Now, these programs are not ideally suited for students of your age who are at first year level. These are ideally suited for startups who have already, companies who are already formed. They are at the stage of finishing their product. So it's premature to discuss these last 2, so I'll not waste your time. But this first one, the Patent Co-Creation Clinic, is ideally suited for students at your level only, who invariably come with half-cooked ideas only. And it is our job to cook them fully, convert it into a edible chapati with the help of our core group, and then either protect it or take it to the market. Thank you. Thank you very much. If you have any questions, I'm ready. Thank you. Yeah, Mr. Saket, I'm done.
Yeah, thank you. Thank you so much, sir. I hope students get some information from you,
Yeah.
whoever is listening. They're first year students, sir, actually. So now they're at the initial stage of innovation and IPR. So if they will understand these things from now, then till final year, I think they will definitely do something, right?
It's certainly for
We organize this lecture on IPR Day just to give the information to our first year student that we have some patents and innovation type of things so that they can aware about these things.
sure. It's a very good
So
about.
thank you very much, sir. Thank you very much for coming in a short time and to accept our request in this short time.
It's my pleasure.
Thank you, sir. Thank you so much, sir.
Back to students.
So have a good day, sir.
Thank you. Thank you very much. Bye bye. And if you have any questions, you can shoot it on my mail.
Yeah, sure, sir. Sure. I will communicate to you.
Yeah, you can give my email ID to them, and we will respond to them.
Sure, sir. Thank you so much,
Okay.
sir.
Okay. Thanks for inviting us. Good day.